Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Mala Chatterjee, a JD PhD student in philosophy at NYU, a fellow at the NYU Law School Engelberg Center for Innovation, Law, and Policy, and a visiting fellow at the Yale Law School Information Society Project. We will discuss her article, Minds, Machines, and the Law, The Case of Volition in Copyright Law, which she co-authored with Gene Fromer of NYU Law School, and which will be published in the Columbia Law Review. So welcome to the podcast, Mala.
Thanks so much for having me.
Yeah. So as you know, I totally love this paper because I myself have a passing interest in some of the philosophy of mind work you draw on in the paper, really fascinating philosophy of mind work, which I look forward to talking with you about a little bit here. But I was wondering if you could start by just talking about volition itself. So like, what is volition and why should it matter to legal scholars?
Yeah, so volition, and as we interpret it in copyright, but sort of more generally in a lot of areas of law, could be understood as a particular kind of mental state. So in the law, we see lots of mental state requirements, either implicitly or explicitly, for legal liability. So one example is we see this in tort law. So we see requirements for either intent or recklessness in certain kinds of tort actions. We see it in criminal law for mens rea. We see certain mental state requirements such as ill will. And we even see it in things like contract law. Offer and acceptance are supposed to be evidence for the existence of some subjective mental state. And volition is an even more fundamental mental state that's required by all areas of law that act for the commission of some voluntary action for the basis of legal liability. So volition might be understood as the mental state that results in actions. So for example, when I move my hand by choice, rather than as the product of some sort of like involuntary bodily spasm, what distinguishes this is that in the former case, I have a mental state that we might refer to as volition. So in the law, in a lot of contexts, when we're interested in really sort of regulating people's voluntary actions, what's sort of presupposed by this is that it's the conduct that is accompanied by volition, which is a particular mental state.
Right, right. So in other words, it sounds like one of the reasons we might care about volition is that the presence or absence of volition would affect whether or not we would attribute liability or even maybe more broadly responsibility for some action to a particular party. Is that fair?
Yeah, that's right. So I think, depending on your perspective of what the law is trying to do, you're going to care about volition for different reasons, but plausibly, if what you think that the law is trying to do is regulate voluntary actions, either because you think doing so is going to produce the right incentives, that people, can choose their voluntary actions and therefore will be responsive to the incentives that the legal system is trying to generate. Or on the other hand, you think the law is in the business of promulgating justice, in which case you're interested in what's fair, what's deserved, and what therefore people are choosing to do. In both cases, you're going to be interested in the presence of volition. You're going to think that it's either inefficient or unjust in a lot of contexts to sort of hold people responsible for things in the absence of something like a volition mental state.
Okay, so as is so often the case, it's really helpful to think of these broader concepts in a more specific context because it enables us, I think, to dig a little deeper into how we actually apply them in practice. And in your paper, you use one of my favorite areas of law, namely copyright law. So maybe you could talk a little bit about how we think about and use volition in a copyright law context. In other words, why does volition matter in thinking about copyright?
Yeah, so copyright law has had a kind of interesting relationship with volition because there appears to be a pretty unique volitional act requirement in the context of copyright. In other words, copyright requires that the production of an infringing copy be attributed to the person that's being held responsible for infringement. But in the context of technology providers, so corporations that are providing technologies which are then used by potential consumers in order to produce infringing copies, it's not sufficient from the perspective of copyright law that the technology provider volitionally provide the technology. So it's not enough that such technology providers have chosen to provide a technology which can then be used to make infringing copies. Rather, copyright asks for volition at a particular point in the causal story. In other words, it asks that the production of the infringing copy in particular be attributed to the person that's being held responsible for copyright infringement. So that might sound a little abstract, but to sort of see how this will play out, imagine that I just directly make a copy of something. Well, here, clearly I've done something that's volitional, and if it's infringing, then I could be held responsible for it. But if we instead imagine that I'm a technology provider and I just put out a copy machine that then someone else comes along and makes use of in the production of a copy, then here copyright law would say that it's not my volitional action that's resulted in the copy. Rather, it's the action of the person using the copy machine. And plausibly what's underlying this, copyright law doesn't want to sort of entirely discourage technology providers from providing technologies that could be, useful for non-infringing purposes, such that, anyone who is in the interest of putting out something like a copy machine would then be discouraged from doing so because out of fear that sort of anyone who comes along and then volitionally uses it in an infringing manner, they would then be held responsible for it.
Yeah, I thought this was a really interesting subsidiary part of your paper because it really made me kind of think about Sony, Grokster, Aereo, all these kind of canonical cases through a kind of a different sort of lens. I always thought of them as like technology cases in a sense, but you really show the extent to which the court is wrestling with to whom to attribute the volition behind the copying act, and how like it seems like in Sony essentially the court is saying, well, the machine isn't doing the copying on its own, it's the consumer who's operating a machine who's kind of making the choice, exercising volition to copy. But then it seems like that gets really complicated, or kind of the court starts to waffle to some degree in later cases. Am I right in seeing the court kind of struggling with how to think about volition in the context of increasingly complicated technology?
Yeah, I think that's exactly right. So in the simple case, with the imagined copy machine, it seems really natural to think that if I, as a technology provider, put out a copy machine and then, someone comes along and uses it to produce a copy, then that's their action and not my action. And so they should be held responsible rather than me. But our thought is that we shouldn't conclude on this basis that it's never going to be the case that a machine provided by a technology provider should be regarded as volitional in the eyes of copyright law. In other words, as we imagine copy-making technologies getting more and more sophisticated, it becomes less clear that we shouldn't think of the copy machine as sort of acting on behalf of the technology provider rather than merely just being used by the customer. So one case that really sort of brings this puzzle to light, we discuss, has some language in which it basically says that, there's a fundamental difference between a customer just using a technology provider's copy machine versus a customer requesting the technology provider's human employee to sort of produce the copy themselves. But then the question is, if a human employee using a technology to produce a copy thus counts as sort of volitionally acting on behalf of the technology provider, this raises the question of why a really sophisticated copy machine that sort of has a lot of the very same functional capacities as the human employee in question shouldn't also be regarded as kind of the agent of the technology provider, such that it can also be held responsible.
Yeah, I mean, one thing that really I hadn't thought about before was the way in which, like, the way we use algorithms today to kind of execute increasingly complicated kinds of actions. I mean, at a certain point, when the algorithm is sophisticated and complicated enough, it's almost tempting to say that the algorithm itself is making choices about what to do or what not to do. And I guess then the question is, like, is that the right way to talk about an algorithm at all?
Yeah, no, I think it's like very unnatural to sort of think about algorithms as making choices or, acting or making decisions. And in some sense that makes a lot of sense because these are concepts that we've sort of developed with humans in mind. But the reason that we sort of have to go to first principles in light of these algorithms sort of replacing what were traditionally human actors' decisions and actions is that we're now forced to sort of ask what the law really cared about. So, what was the law really interested in tracking? So, when the law says, for example, that a human employee standing in as an intermediary between the copy machine and the customer would therefore satisfy what copyright law is interested in having this volitional act requirement, we're now forced to ask why? What is it about this human employee that's sort of standing in between the copy machine and the customer that suddenly makes it the case that the technology provider is responsible? And whatever this property is that the law is interested in, is this something that a mere algorithm could also possess, such that for the purposes of the law, for everything that the law in, for example, its volitional act requirement is really trying to track, the algorithm really is acting in at least the law's eyes, if not in a literal sense, such that the purposes of these legal requirements would best be achieved by sort of applying them to at least certain kinds of technologies that are like humans in all the relevant senses.
Right, right. So just to push this one step further, I mean, do you think that new technologies like machine learning, deep learning, other kinds of sort of uh, algorithmic developments that kind of can occur without human intervention or even understanding, does that like further complicate this question or push it into a new place? Or is it just another version of the same phenomenon that you're talking about already?
I definitely think it complicates it in the sense that there's this sense of autonomy, of autonomous sort of learning and decision making, choice making that gets introduced into the kinds of technologies that we're imagining. And plausibly, that could cut either way. So you might think that now that the technologies are sort of developing and starting to learn in ways that move away from the complete grips of the technology provider's control, as is in the case of a simple copy machine, then we might think that the sort of relationship between the technology provider and the algorithm becomes more tenuous. But on the other hand, it also seems like as technology becomes more sophisticated, it becomes more human like. And so to the extent that the law thinks that humans can sort of be full agents on behalf of other humans, it seems like the more technology becomes agent like in the relevant senses, such that it has the capacity to sort of take in considerations and evaluate them and then make a decision on the basis of those considerations, it starts to seem more like it potentially has the capacity to sort of act as an agent of the technology provider, just as the human employee does in copyright law's eyes.
Yeah. So obviously what you're talking about here in some deep sense is sort of whether a machine, a non-human machine, can have a mental state, or at least something that we might want to functionally describe as a mental state. And in your paper, the lens you use to think about that question is comes from the philosophy of mind. So I wonder if you could talk for listeners who might not be familiar with these philosophy of mind concepts, sort of how do philosophers think about that question of mental states and whether or not we can and should describe machines as having something that qualifies as or is at least akin to a mental state?
Yeah, so philosophers have spent really decades thinking about the nature of mental states and whether mental states are the kinds of things that, for example, a machine could really have, or what kinds of mental states a machine could have. And so, in looking at the law and in seeing all these mental state requirements in the law, and also as we come up against the question of how or whether or when various so-called machine actors can satisfy these mental states, it's really natural to sort of look at the work that philosophers have done and the distinctions that we get from philosophical thought in order to sort of try to make sense of how to even approach the question of whether machines should ever be regarded as sort of mental in the eyes of the law, such that they can satisfy mental state requirements like volition. And in particular, from philosophical discussions, we get this conceptual distinction between two properties of the mind, two concepts of the mind. And these are, on the one hand, the conscious properties of the mind, and on the other hand, the functional properties of the mind. So to see this distinction, you can consider two examples, a human and a thermometer. So a human and a thermometer both share certain functional mental capacities, namely the ability to detect heat. If you expose a human and a thermometer to heat, they'll both respond to it in some kind of functional manner. The thermometer will tell you what the temperature is, and the human will, start sweating or turning red or whatever else it might do. But only the human has the conscious property of feeling heat or of experiencing heat. So the human will have some sensations that accompany the encounter with heat in the way the thermometer will not. Now, this distinction between conscious and functional understandings of the mind was probably most famously brought to people's attention by John Searle's Chinese room argument. So listeners might be aware of this argument, but basically this argument was Searle's attempt to challenge the idea that there could ever be an artificial computer that really has conscious rather than merely functional properties of the mind. And in particular, Searle asked us to imagine a monolingual English speaker sitting in a room with a rule book that perfectly sort of correlates Chinese characters that are inputs with outputs. And he's asked to sort of take in inputs of Chinese characters and respond with the appropriate outputs. And Searle asked us to imagine that the man gets so good at this that he, from the outside, is sort of functionally indistinguishable from a Chinese speaker. So in a certain sense, he's functionally equivalent to someone who really understands Chinese. Nonetheless, Searle tells us he would lack the conscious experience of understanding Chinese. So this is supposed to be a case in which the conscious and the functional come apart. Now, this distinction, even for those who sort of reject the force of Searle's argument, remains really important among philosophers, because years later, another really influential philosopher of mind, David Chalmers, pointed out that even human mental states can be understood entirely in terms of either their conscious or their functional properties. So we can consider one example, the pain mental state. Pain mental states have various conscious properties, so it feels very unpleasant to be in pain, but they also have purely functional properties, so properties that are just about the causal role that they play in the context of a system. For example, they tend to be caused by some injury, they tend to cause humans to say the word ow, they tend to force you to sort of avoid the stimuli that resulted in the pain, and so on. Okay, so what's the upshot of all of this for the purposes of our legal theorizing? Well, the implication is that since we have these two distinct concepts of the mind, and since sort of regardless of what you think about whether we could ever have genuinely conscious computers, basically everyone agrees that machines can replicate the functional processes of human mental states. So just like in the Chinese room case, as long as a machine sort of functionally operates like a human mind, we can regard it as sort of functionally identical to whatever mental state we're interested in. And so this is significant because for each of the law's mental state requirements, it remains an open question whether what the law is really interested in tracking is something conscious or something functional. This is a question that we might not have had to ask before, because up until now, the law has been interested in human actors where the conscious and the functional often overlap. But if the law is ever only interested in a functional mental state, then this means that it's something that could be possessed by a machine, maybe one that already exists, such that the machine should be regarded as mental in the eyes of the law.
Right. Yeah. And this disaggregation of consciousness and functionality was really provocative and interesting, I think, and sort of really helped me understand better how we don't have to be purely in science fiction world to be thinking about why these questions would matter as in a practical sense, given the technology that we actually have today. So to sort of illustrate why this is so helpful, maybe you could talk a little bit about what it would mean for a machine to potentially have a functional mental state in a copyright context in relation to volition. In other words, what would kind of functional volition look like for a copyright adjacent machine?
Yeah, so Jeannie and I consider a couple different examples in the paper of what you might be tempted to call a functionally volitional machine, depending on what you think copyright law is really trying to get at. So if you accept that copyright here is ultimately tracking functionality rather than consciousness, then we can ask the question, okay, what functional properties is the law interested in? So when we imagine the human employee that's sort of manning the copy machine, who the law tells us would always satisfy this volitional act requirement, what properties of this human's mind is the law really interested in? And we think that it's ultimately not the conscious properties, but rather the functional ones. But we might ask which functional properties the law is really interested in. So one possibility is that the law is interested in the fact that this human employee has the capacity to, when requested to make a copy of something, sort of evaluate that it's potentially infringing material, and to perhaps decline to make the copy on that basis, even if, she ultimately chooses to make the copy. But note that this functional capacity is something that seems quite basic. So it wouldn't be possessed by a sort of rudimentary copy machine that's, quote unquote, compelled to make a copy when the customer presses a button, but it would be possessed by something like a computer that has the capacity to sort of evaluate whether something is likely to be expressive and to flag it, and to then even decline to make a copy on the basis of this out of fear of sort of infringing on copyright. So that would be a pretty simple account of what a functionally volitional machine might look like. On the other hand, you might think that the law is interested in something more sophisticated, such as the human employee's capacity to determine whether some instance of copying is likely to be fair use. Now, this is something that would require a much more sophisticated algorithm, because it would be one that has the capacity to, first of all, figure out how the expressive material is being used, the likely effect on the copyright owner's market, and so on. So this would be a much more sort of high bar for a functionally volitional machine. But these examples should sort of get you in the flavor of thinking through, okay, if the law really is just interested in functionality in this context rather than conscious experience or how the human employee is feeling while making the copies, then these are the kinds of questions that we need to be asking, namely, what functionality is the law sort of interested in tracking, and what would a machine have to look like in order to have it?
Right. So to the extent that what we're concerned about is sort of the ability to make a judgment call, as it were, as to whether or not to exercise a particular, take a particular action in a particular context. In other words, the volition is either do X or not do X. how should we think about the burden of, you know, of determining whether or not a machine is going to take that action in relation to the goals that we're trying to accomplish with copyright? In other words, like, for example, if a particular algorithm or a particular machine learning technology is really efficient at accomplishing something in the market that consumers want, but is like not attentive to copyright related questions or insufficiently attentive to copyright related questions, like how might the kind of framework you're proposing affect the way we think about whether or not that technology is justified or not under the circumstances?
Yeah, I think this is a really important question, and certainly the question that I think we take, or one of the questions that I think we take our piece to be really raising. So most of the analysis that we've done here is intended to be somewhat positive rather than normative. In other words, we've looked at what the copyright volitional act requirement seems to be interested in. We argue that it seems like it's ultimately interested in conscious rather than, or in functional rather than conscious properties. And on this basis, we've sort of argued that it follows that machines could be regarded as sort of agents of the technology providers, such that the technology providers should be held responsible. But of course, this raises a host of further normative questions about whether this is what the law should really look like. So, first of all, you might worry that this produces somewhat strange incentives for technological advancements. So maybe it makes it the case that now companies will be less inclined to produce more sophisticated technologies that would be more likely to be sort of regarded as an agent of the company, and to therefore sort of expose the corporation to more legal liability. On the other hand, you might wonder whether copyright law really should care about the conscious experience of an infringer rather than merely functional volition. So if you took this line of argument, then maybe you would think that, for example, copyright's doctrine of subconscious copying, according to which a human who makes a copy without any conscious awareness of doing so is held responsible for copyright infringement, which this is a part of why we sort of make the argument that ultimately the law, as a matter of fact, seems to really be interested in functionality. But you could argue that this is a really bad rule. It overburdens people. It makes it too easy to sort of infringe on people's copyright. And so in either direction, you could kind of question whether the volitional act requirement is really ultimately desirable. But note that these are all questions, again, about whether the requirement is a good thing, rather than whether, as a sort of conceptual matter or a metaphysical matter, it's the kind of requirement that should be satisfied by machines. So we think that the way that the courts have been thinking about this so far, which is a kind of humans are always volitional and machines are never volitional kind of bifurcation, that sort of punts the more fundamental normative questions about what we want the law to be incentivizing, is a kind of mistaken and simplistic approach. Rather, we need to sort of reckon with the fact that machines might be volitional in the very sense that the law is interested in, but it only forces us to sort of ask the question of how we want the law to really look and sort of what requirements we should really have.
Yeah, I mean that's what really hit me when I was sort of like toward the end of your paper, was that, you know, at the end of the day, this is really fundamentally a policy question about what we want to accomplish with copyright law in the first place. And one of the ways that thinking about mental states functionally in a copyright context seemed really useful to me was, like, for example, when it comes to fair use, which you talk about quite a bit in the paper, in many consumer contexts, especially in relation to like what I would call like consumptive fair use, our expectations on consumers in relation to sort of making conscious judgment calls is really pretty low, right? I mean, we basically kind of write them out of the picture. And it seems odd to say that, you know, consumers making consumptive fair uses can just make them willy-nilly, and we're not gonna question them. We're not going to attribute any kind of culpable mental state to them. But when we look at a machine doing the same thing, because it does so on a kind of a different scale and produces different results, then we're going to think about the functional mental state differently. I mean, it seems like ultimately we're sort of just making a judgment call about the outcome rather than something fundamental about the nature of the decision making in question.
Yeah, I think that's a really great example of a similar kind of mistake that it seems like people thinking about copyright law are really tending to make, and it's kind of natural to see why. So copyright law, because it's had already a sort of long history of having to deal with technological advancement, copying technologies, that it's already sort of had to grapple with this question about how we should think about so-called machine actors for a really long time, even if it's a question that now other areas of law are starting to have to grapple with. And we see this kind of blanket declaration that humans and machines are different in some way that matters, without sufficient sort of engagement with the question of what this difference is supposed to be, why it's relevant to what the law is trying to do. And as a result, courts are sort of getting away with avoiding the really hard questions. And as technology becomes more and more sophisticated and more capable of doing the things that humans are able to do, oftentimes even more efficiently or better than humans are able to do, it becomes less plausible to sort of cling to this assumption that it's just different because one's a human and one's a machine. Rather, we need to ask the question, well, what are the relevant factors? And are those particular factors ones that are different between humans and machines? Or is it the case that in the relevant ways for the purposes of the law, they're the same?
So, Mala, in closing, your paper focuses really specifically on kind of volition in a copyright context. Do you think that the observations you make in the paper can be generalized away from just a copyright context and applied kind of more broadly to thinking about machine actions or actions taken by machines in other legal contexts?
Yeah, definitely. And I definitely think that our focus on copyright's volitional act requirements is intended more than anything as a case study. So, as I said, copyright is a great sort of example of thinking about minds and machines in the eyes of the law because of this long history of mechanical copying and this resultant strange volitional act requirement that has kind of assumed that humans, always satisfy this mental state requirement while machines never do. But as I sort of started off by saying, we actually see mental state requirements in practically every area of law. So we see more substantive mens rea requirements in criminal law, tort law, but really any area of law that has an act requirement will fundamentally be sort of asking for a volitional mental state, because these are the mental states that distinguish actions from other kinds of events. So whatever you might think about copyright law in particular, this is really a sort of more general question that the law is going to have to reckon with, which is, whether and when in all these different contexts, the machines that might be replacing humans should be regarded as sort of satisfying these mental state requirements. So we might ask whether an algorithm is capable of having discriminatory intent, or whether a bot that produces speech is capable of having actual malice if it produces something potentially defamatory towards a public figure. We might ask whether bots that are price-setting algorithms for corporations are capable of colluding in the eyes of antitrust law. There are just so many questions that we might be forced to ask. And we think that this framework, and in particular this distinction between the conscious versus functional understandings of mental states, allows a kind of way of tackling all of these questions. So for each of the law's mental state requirements, we can ask the question, what is the law really trying to do? What is it trying to track? Is it something conscious, or is it something merely functional that actually really could be and in fact is replicated by even existing machines already. So in the paper, we discuss sort of two examples outside of the copyright infringement context, namely the volitional act requirement in criminal law rather than copyrights on the one hand, and then copyright law's requirements for authorship rather than infringement on the other hand. And we just make the point that one could coherently hold the view that although functionality is all that matters for the purposes of copyright infringement, consciousness matters in both of these other contexts. So, for example, you might say that in criminal law, because of the sort of punitive functions of criminal law, it really matters that the agents that are being held responsible have a conscious experience of what they've done. Or on the other hand, you might think that because authorship status in copyright, unlike infringer status, involves possessing ownership rights, it involves legal personhood. Here, actually, we should think that consciousness matters rather than just functionality. Now, of course, I'm not defending either of those views, but it's just a kind of example of how this framework could be applied in different mental state requirements and in different contexts, and how for each context in which you apply it, you're going to have to ask the question, the sort of fundamental philosophical question, what is the law really trying to do here? And is it something such that it should matter to us whether the relevant actor is a human or a machine?
Awesome. Well, thank you so much, Mala. This was a fantastic interview on a fascinating subject and a really excellent paper that I encourage people to read.
Thank you so much for having me.
Hello, ladies and gentlemen.
Those words were spoken by an electronic computer. They are an example of synthetic speech, a product of Bell Telephone Laboratories' research into the basic nature of speech. Knowledge developed through such research may be useful in devising new techniques for transmitting speech over communication systems. To make the computer talk, it is fed punched cards containing the names of speech sounds. The computer combines these sounds, in accordance with the linguistic rules which govern the English language, into connected, intelligible speech. For example, when the sounds for the sentence, "He saw the cat," are fed into the computer in sequence, it says,
"He saw the cat."
The flat, monotonous tones of the computer indicate an absence of the pitch and timing characteristics natural to human speech. When timing information is added to the punched cards, the computer says,
"He saw the cat."
The sentence still sounds unnatural, but when pitch information also is added to the cards,
"He saw the cat,"
the computer speaks in accents almost completely human, except for a slight electronic twang. In the following sentence, most of the variables inherent in human speech have been specified on the punch cards. The computer makes one of the pivotal remarks in the development of the telephone.
"Mr. Watson, come here. I want you."
The present quality of speech synthesis by computer is illustrated in the next example, part of a famous soliloquy from Hamlet.
To be or not to be? That is the question. Whether 'tis nobler in the mind to suffer the slings and arrows of outrageous fortune, or to take arms against a sea of troubles, and by opposing end them. To die, to sleep.
Singing, in purely physical terms, is essentially a matter of pitch and timing. In the next selection, the computer sings a familiar ditty.
Daisy, Daisy, give me your answer too. I'm half crazy, all for the love of you. It won't be a stylish marriage. I can't afford a carriage. But you look sweet upon the seat of a bicycle built for two.
The computer now sings the same tune, but to a musical accompaniment played by another computer. Piano students will notice that the music-producing computer has a rather stylized left hand. Incidentally, synthesizing music on a computer is almost as formidable as making a computer talk.
Daisy, Daisy, give me your answer too. I'm half crazy, all for the love of you. It won't be a stylish marriage, I can't afford a carriage, but you look sweet upon the seat of a bicycle built for two.
To get the samples of synthesized speech we've heard so far, a computer's memory was stored with 34 speech sounds and a set of rules for producing these sounds and for making the transitions from one sound to another. When the computer was fed the names of speech sounds on punch cards, it was, in effect, told what to say. But its manner of saying it, even its dialect and apparent accent, was determined by the rules stored in its memory. The objective of this program is to formulate a minimum set of rules for making plausible English speech. The next two selections, however, were produced by analyzing a person's speech and reconstructing it synthetically on a computer. The objective here is to duplicate the sounds and transitions made by a human speaker, including his dialect and accent. With such a program, the computer sounds like this.
Men strive but seldom get rich. Now, if you don't mind, I'd like to say a few words about Texas.
And now the computer would like to express its appreciation for your attention.
Thanks for listening.